Hello, dear colleagues and partners. We're about to start our webinar, so let's wait for a couple of minutes and we will kick off. Let us know if you hear us well. Please put any pluses or any comments in the chat, which you can find in the bottom right corner. So let us know if you hear us well. So we're going to start. So please confirm if you hear us well. At home, I see your comments that you cannot hear us. Please follow the recommendations I just sent in the chat. Okay, thanks, Florian. And Adham, could you please reload the page and enable the web RTC function in the settings? That should help. Okay. This is the last one in the series of webinars that we held with an attempt to take a look in the future with regard to the draft law which is registered in the Ukrainian parliament. And this webinar is going to be in English, and this is an attempt to take a look and to remind the existing non-resident creditors and to take a look on the possibilities and new opportunities which the new law brings to the existing and new potential business model that non-residents can explore and use. My name is Kirill Muhamedyanov. I'm a financial sector specialist in the Ukraine Proceeds project. And I'm not alone today. We have other speakers who are Vitaly Smerdov, who is our tax and accounting consultant. Also, later you will hear and see our colleagues Katerina Kirsta, who is an analyst in the project, and Taras Burhan, who is a legal consultant of our project as well. So, Ukraine Proceeds project is implemented by International Finance Corporation, which is a member of the World Bank Group, in partnership with our lovely partner, which is the Swiss Confederation. The main project's aim is to improve access to finance for small and medium farmers in Ukraine by introducing the crop receipts as a financing instruments in Ukraine. And the main project objective is to facilitate and increase financing to the agricultural sector with the use of this relatively new instrument. Our project partners are two ministries, among which are the Ministry of Economic Development and Trade and Agriculture of Ukraine, and the Ministry of Justice, and of course a lot of private sector representatives, among which creditors, input suppliers and distributors, financial institutions, and of course processors and trading companies, and definitely farmers. The webinar outline will look like this. So we will remind you what the crop receipts are and why this instrument became a top choice for creditors to secure the lending to Ukrainian farmers, and how international crop receipts operate in Ukraine today, because we already have practical examples, and what are the new business potential opportunities available under the new law, which is already tabled in the Parliament and recommended for the first reading. Crop receipt instrument includes two parts. The first one is the farmer's unconditional obligation either to supply commodity or pay in cash in the future, and this obligation is backed by the future crop collateral. So there are two parts in one document. There is a pretty flexible format as of today. So the creditors can put almost every provision that they think would be useful to secure the lending. And in the new law, we're going to introduce the standardized form of the crop receipt, which will include the majority of existing provisions, but with this, in the same time, we will leave the opportunity to put any provisions, and in that case, a creditor will use an individualized form of the crop receipts. As of today, all crop receipts have to be notarized and registered in the public crop receipt register and another register on encumbrances with the current assets. All crop receipts can be endorsed, so that creates the opportunity to use this instrument as a payment method between distributors and input suppliers, but not limited to this model. So the idea is that any crop receipts can be endorsed from one creditor to another if there is no provision which prohibits such an action. And one of the most important features of the document is that you don't have to go to a court in case of default. So you just have to go to a notary, get a notary read, and use the advantages of quick and relatively simple out-of-court enforcement in Ukraine. So this slide is, of course, a big proud for the whole team. As you can see, we have launched our project in 2015, starting with only one pilot oblast, and then decreasing the number of oblasts in the pilot. And in 2018, we launched a national crop receipt register, which enabled the whole country users to use this instrument. And you can see as that the growth was rapid, and as of today we have already $1 billion US dollars financed under almost 4,000 crop receipts in terms of volume and quantity of all crop receipts issued. So this is quite a big number for such a relatively new instrument in Ukraine, in our opinion. So almost 150 creditors on the local market and international companies used this instrument to secure their lending. 40 crops were pledged to secure credits, including those from grains and oilseed sector, but also from fruits and vegetables, including niche crops and organic crops. And you can see that the variety of farmers that use this instrument also is huge, and it varies from 1 hectare, even less than 1 hectare, to tens of thousands hectares in case of agri-holdings. It is worth mentioning that even farmers from the conflict-affected area of Donbass also used this instrument and increased the profits. In terms of types of obligations, there are two crop receipts. The first one is commodity crop receipt, where you have an obligation to deliver fixed quantity of a single crop with the possibility to specify the formula for conversion of crops, quantity depending on its quality. And the second type of existing crop receipts is a financial crop receipts, where you have an obligation to sell your harvest, your grain, and then to pay the amount of cash according to the formula which accounts a crop quantity. It can be fixed or indexed to, for example, foreign currency rate or any kind of indexes that exist in the market. Talking about collateral, so there is a certain link to the land plots which farmers that are going to issue crop receipts have to own or have legal rights to operate on that specific land plots. So there is a certain location area with the cadastral numbers which have to be specified in the document. And after the harvest is actually harvested, so the corresponding tonnage of agricultural product is considered to be collateral under a crop receipts. So you don't have to prove that this certain amount of grain originated from that exact cadastral numbers once you have found this grain in warehouses or in silos specified in the crop receipts. Of course, there are several other similar documents that used worldwide and in Ukraine particularly, but in our opinion, crop receipts include the advantages of each of them. We're talking about forward contracts, we're talking about future crop collateral, and promissory notes that can be evaluated or simple, and these documents are widely used in Ukraine as well. So in our opinion, in legal terms and in terms of creditors' right protection, crop receipts is the strongest instruments. So I will give the floor to Vitaly to explain what are taxation rules for international crop receipts.
Thank you, Kirill. I just have a few commentaries about taxation. For today, it's quite simple. We have several group of tax consequences. First of all, it's VAT. Under the VAT, There's two general group of operations, of consequences. First of all, it's operations with crop receipts as an instrument, as a debt instrument, and such operations are VAT exempt, as you can see. Second group of operations, it's goods services flow under the crop receipt, and such operations are the object for the VAT. It's 20%. It's a general rule. It's quite simple. The next group of tax consequences under the international crop receipts instrument, it is withholding tax consequences. You shall pay such tax when Ukrainian person transfer some amount of money under the crop receipt to the non-resident, and so this Ukrainian person should withhold this tax in amount of 15% from such amount of money, but not from all amount of crop receipt, only from the interests and from amount of penalties and fines. However, if there is a double taxation treaty between Ukrainian and jurisdictions where the non-resident set up, and such double tax treaties have its common rule, such amount of tax could be reduced by such double tax treaty, reduced to the 0%. It's also general rule. It's nothing difficult. And that's all. All other tax consequences are general, and there's nothing special about operations with crop receipts. That's all. I transfer board to Katerina.
Thank you, Vitaly. But I would like to say that there is nothing special with crop receipts, but it's good to work with crop receipts. And as our example and practice proved that international crop receipts are also operational in Ukraine. We have good cases, about 24 of successful cases when international companies credited Ukrainian farmers and secured their lending via international financial crop receipts. Like financing volume on these cases is about $10 million. So international crop receipts prove to be successful and operational today, but we are not standing still and watching how this instrument is developing just within the current limits, but we want to expand those limits and lift any possible restrictions and limitations that restrict further development of the instrument. And for this reason, we, together with market participants, developed a draft law on amending the crop receipts law and other legislation of Ukraine in order to enable more opportunities within crop receipts. We had numerous consultations with biggest creditors that use crop receipts today, with public stakeholders, with government agencies, to have this comprehensive draft law that addresses main current bottlenecks that sort of limit crop receipts to their role that they play today, because we see that potential for crop receipts is much bigger. So we have developed this draft law. It was tabled to the parliament this January, and as of this month, in April, it was recommended already by the core committee, like steering committee leading our draft law, for the parliament to be adopted in the first reading. We anticipate that first reading will take place as soon as the COVID-19 quarantine is over and Parliament is back to its normal operations. So tentatively, we plan this for May, early June. So let's see how things develop. And now I would like to actually say what are the benefits coming with the new law. So the new law is primarily aimed to introduce crop receipts in a new form, in a new modern form, presenting them in securities existing in the form of electronic documents. We believe that because of this, innovative form, we will make crop receipts transactions easier, cheaper, and simpler and more accessible for farmers and for creditors to work with. We also suggest two options for crop receipts. As Kirilo mentioned, today they exist in a flexible format. The law only requires certain provisions to be included into the document in order for this to be a crop receipt, but there is no template, no guidance how this document shall look like. And market developed in a way that more or less we see the pattern among those crop receipts that were issued. So we introduced the option of a crop receipt according to the standard template, and we believe that this will be a good ground for potential secondary market for crop receipts, because it is easy to trade and exchange instruments that are of a clear, simple, understandable nature and easy to for potential creditors to see and evaluate. But a part of the new form, we also to include certain provisions that expand current applications of crop receipts. We suggest this instrument for other segments of agriculture, apart from the crop production, where crop receipts proved to be very efficient today, but crop production mainly remains the only industry of the agriculture that uses agricultural crop receipts. That's why we call them in English even crop receipts, although in Ukrainian, if you do literal translation, it is an agrarian receipt. So we want to introduce agrarian receipts to more agricultural segments, namely to animal farming industry, to enable pledge of livestock and livestock products. We want to enable cooperatives to issue crop receipts, because we believe that cooperatives will serve as certain aggregators and will enable smallest farmers to have access to finance on the same good, favorable conditions as their competitors do that represent bigger agricultural farms. We also, because of naming crop receipt clearly as a security, we enable more refinancing opportunities for current creditors that already received crop receipts from farmers. So we want to enable for them to refinance themselves and get opportunity to expand their credits to farmers. Namely, we introduce provisions that will enable crop receipts trade on a stock exchange. We want to have a securitization of agricultural receivables, including crop receipts, and because of crop receipts being easy electronic documents of standard form, we believe that they will serve as a good ground for collateral to back the future instruments to be issued. And last but not least, we introduce a more flexible, but at the same time more secure enforcement for crop receipts. Crop receipts today have an option for creditors to not to go through a court, but to go via quick out-of-court procedure. Next day after the default on crop receipt, creditor may contact the notary, get a notary read, and immediately go to the enforcement service to have the crop receipt enforced. We have a good practice, good examples of real cases when creditors actually followed this procedure and got their debts repaid. But although we were able to identify certain, let's say, gaps that proved that the enforcement procedure may still be enhanced, and we introduce targeted provisions that are aimed to make creditors' rights more protective. Namely, the crop receipt collateral that serves as a base to repay the crop receipt debt. But when the collateral is not there, creditor has the only chance now only to go to the court. But we want to enable creditors to seize other assets of the borrower, of the farmer, in case the pledge is not available. So these are like high-level things and benefits coming with the new law, hopefully to be adopted soon. Now I'd like to pass the word to Taras. Taras will highlight business opportunities, how models operate today, and what the potential impact of the new law. Please, Taras.
Katerina, thank you for giving me the floor. I hope that you can hear me well. Please confirm. Okay. So I will be talking about business models which are actually currently available and which will remain available in the light of prospective legislation. There are at least two business models which can be used. First of all, it's commodity or financial crop receipts to secure the contract. And here we can talk about forward contract, loan agreement, or supply contract. And the second potential model is financial crop receipts to repay the contract. And here we are talking about loan agreement or supply agreement. Actually, it would be probably fair to mention that international crop receipts were first started to be used by market participants last year, because in February of 2019, Ukrainian currency legislation was changed. Actually, we have enacted a new law on currency, and also the National Bank of Ukraine introduced a number of regulations on the currency control topics. And among those regulations, we find actually statements that non-residents of Ukraine can be creditors under crop receipts, because before that it was sort of not prohibited by law, but it was not clear if non-residents can be creditors under crop receipts. And in this regulations by the National Bank of Ukraine, the National Bank of Ukraine clearly stated that non-residents of Ukraine can be creditors under crop receipts. And secondly, these regulations, which were introduced last year, provide clear grounds and procedures for purchase of foreign currency by the farmers and transfer of such foreign currency under crop receipts to foreign creditors. So there are like clear grounds, clear procedures, what should be done and what should be followed in order to buy and transfer money outside of Ukraine based on financial crop receipts. Let's have a look at the first model, which is using crop receipts to secure the contract. On this slide, you can actually see how the market is using this model at present. And at the next slide, we'll talk what changes to this model will take place in light of the prospective legislation. So the relationship, first of all, the relationships between the non-resident creditor and the Ukrainian farmer are governed by the contract. And actually, there could be three types of contract. As mentioned before, there could be a forward contract under which a foreign trader is making advance payment to a Ukrainian farmer, and Ukrainian farmer is obliged to deliver goods to a foreign trader. The second type of the contract, which can be used for this model, is a loan agreement under which foreign lender is disbursing loan to a Ukrainian farmer as a borrower. And the third contract, which can be used for this model, is a supply contract under which foreign supplier is delivering goods to a Ukrainian farmer who is buying such goods or products. On the structure, in addition to signing under this model, in addition to signing the contract, the farmer is issuing financial crop receipt or commodity crop receipt, depending on the choice made by the parties. And this crop receipt is issued to the creditor, and it clearly states that it is used to secure the contract. To a certain extent, we can say that there is like a parallel debt, because on one hand, the farmer is obliged to perform under the contract, and on the other hand, the farmer is obliged to perform under the crop receipt. But this situation is only temporary, and it ends depending whether there is an event of default or there is no event of default. So what happens if there is an event, if there is no event of default? So when we are saying that there is no event of default, this basically means that the farmer is performing its obligations under the underlying contract. So if we are talking about forward contract, the farmer is delivering goods to a foreign trader. If we are talking about loan agreement, the farmer is repaying loan and interest to a foreign creditor. And if we are talking about supply contract, the farmer is paying under the supply contract the purchase price to the foreign seller. So if there is no default under the contract, the farmer performs under the contract, and the crop receipt is returned to the farmer. So basically, crop receipt is not used. It is, let's say, was kept in the pocket of the creditor. It was not used. The farmer performed well, so the creditor returns it back. If, however, there is an event of default under the contract, then the obligations under the contract are replaced, but in full or partially, depending on the provisions of the contract, with the crop receipt, meaning that the creditor, basically now the creditor can proceed with fast track enforcement under the crop receipt, and basically not to use the contract to the relevant extent, in order to enforce its claims. If, however, the crop receipt provides only partial coverage under fast track enforcement, then the creditor typically can still proceed like with normal litigation, going to the court and obtaining court judgment for the rest of the claims, if there are any. So at the next slide, let's have a look at this model in light of prospective legislation. First of all, this model is possible. It can be used more or less in the same way, but we have to take into account a few nuances which will be introduced by the new, most likely will be introduced by the new law. First of all, as my colleague mentioned, crop receipts will not exist as paper documents, right? So there will be no crop receipt like in a paper form, on a special notarized paper, notary paper notarized by the notary. But they will be formed and exist as electronic document in the registration system, in the register. So this means that the crop receipts can be formed fast, easily online. So this is the first nuance which should be taken into account. Secondly, we also have to remember that the draft law suggests that the crop receipts will be upgraded to the status of securities, because at present, if you look at the definition of crop receipts, you would realize that they are just documents. At present, crop receipts are documents. Of course, they have all of these features which attract market participants and allow market participants to use them efficiently, but they are defined as just documents. The draft law upgrades them to the status of securities. And of course, the securities are classified under Ukrainian law as a specific type of property, so it is asset. And since securities are assets, one would need a special legal ground to acquire such assets. And Actually, there could be a few grounds, but we believe that such probably the most easy one, legal ground for such acquisition of such asset would be sale purchase agreement of crop receipt. So in addition to signing usual contract, like forward contract or loan agreement, basically the parties can also sign a sale purchase contract for purchase of crop receipt. This contract can be signed together with the main contract. And under such contract, we believe that it should provide that a non-resident creditor is buying a crop receipt for some minimum or nominal, or actually not nominal, some symbolic amount, let's say $1, with an obligation to sell it back to the farmer if there is no default. Right. So there is a legal ground. Sale purchase agreement is for crop receipt is a legal ground for the crop receipt to be transferred from the farmer to the creditor. The creditor pays just some symbolic amount, and there is an obligation to sell it back, give it back to the farmer if there is no default. If, however, there is an event of default, then the situation develops similarly as it is now. Basically, the main contract specifies that the obligation under the main contract is replaced, again, in full or in part, depending on the will of the parties, with the crop receipt. And basically, once this happens, the creditor can proceed to enforcement. Most likely, there is next day default under the crop receipt itself, because these are different defaults, default under the contract and default under the crop receipt. So there is default under the crop receipt, and the creditor can proceed with fast-track enforcement for the crop receipt. Once the obligations are performed, there is also one more nuance. Once the obligations are performed, either voluntarily or through enforcement procedures, the creditor is obliged to actually make a notice in the register that the creditor, that the crop receipt is not existing any longer. So, and basically there are two scenarios. If the performance was done under the crop receipt, then the mark is the crop receipt is performed, and if it was the performance was made under the contract, the mark is crop receipt terminated according to other grounds. And the beauty of the prospective legislation is that this actually marking in the register can be done online, because at present the creditor can take this physical hard copy of the crop receipt, make a stamp performed, and send it back to the farmer, which actually takes time, probably some spending for delivery. Sometimes the creditors forget to do this, and there are penalties, some penalties for not doing this. So the draft law suggests that this can be done easily, online, very, very efficiently. And also, I would like to, with respect to commodity crop receipts, I would like to mention one more provision which is suggested by the draft law. When we are talking about commodity crop receipts, as it was mentioned by my colleagues, the farmer is obliged to deliver goods, and the goods are typically taken into ownership of the creditor. And the draft law suggests that if the creditor acquires title to collateral, which is if non-resident creditor acquires title to collateral, to agricultural goods through the enforcement procedures, then such goods are placed into so-called customs warehouse regime under Ukrainian law. And then customs procedures and customs formalities should be fulfilled by the bailiff. Because, of course, the non-resident creditor who is outside of Ukraine cannot fulfill all the requirements of a Ukrainian legislation in order to physically ship the documents outside of Ukraine. The farmer at this stage, if we are talking about default situation, is not cooperative. I mean, he or she or that company is not willing to do any steps to help the creditor. So the draft law clearly states this is the bailiff who is entitled, who should do all of these customs procedures and formalities so that goods are cleared, released, and can be shipped outside of Ukraine. Okay, the next, on the next slide, actually, we made an example of the structure under the draft law, because we understand that this may sort of sound a bit, maybe at the first glance, more complicated than it is at present. So we made an example with actually naming documents, some suggested timelines, and some examples of provisions in the documents. I will not go in details on this slide because the presentation will be delivered to the participants by email after the presentation, after this webinar is over. And you are welcome to look into the slide in detail. I would like to just emphasize that in addition to signing the main contract, it will be necessary to sign a sale purchase agreement for purchase of a crop receipt for some symbolic price. And if there will be no event of default, the crop receipt will be returned to the farmer. If there is an event of default, the non-resident creditor will use such crop receipts in order to enforce through fast-track enforcement provided by Ukrainian legislation. At the next slide, we can look at the second potential model for using crop receipts internationally. This is using financial crop receipts to repay the contract. And in this model, actually, this model is applicable to the situations where the farmer has a payment obligation, to the non-resident creditor, and most typically the payment obligation arises under either loan agreement, that the farmer has to repay the loan and interest and other payments, or another scenario is the supply contract, where the farmer has a payment obligation to pay a purchase price to a non-resident creditor. So in this scenario, in this model, instead of, if we compare this model to the previous one, instead of waiting for occurrence of an event of default under the contract, in this model, the parties, the farmer and the creditor, agreed to replace in full or in part farmers' obligations under the contract with farmers' obligations under the crop receipt at much earlier date chosen by the parties. So basically, the parties are not waiting for event of default. Here, the financial crop receipt is used as means of payment. Once financial crop receipt is issued, the farmer does not have obligation to pay under the contract any longer, in full or in part, depending on the amount for which the crop receipt was issued. But the farmer immediately has an obligation to perform under the financial crop receipt at the date, at the payment date specified by the crop receipt. Under the draft law, in order for financial crop receipts to be used as a means of payment, as described in the structure, the relevant contract, either loan agreement or supply contract, should specifically provide so. And if the parties don't have relevant provisions at the state from the outset of the transaction, meaning the contract is silent in this respect, it's not too late. I mean, one-page simple amendment to the contract would with the relevant wording would enable application of this model, so that the crop receipt is used as a means of payment. And also the draft law, probably for avoidance of any doubt, suggests that financial crop receipts should be added to the list of financial documents that are used for cross-border settlements or cross-border payments. So after the draft law is enacted, there will be no questions whatsoever that the financial crop receipts can be used as means of payment, not only for domestic transactions, but only for cross-border transactions, repaying the farmers' debts to the non-resident creditor. Okay, next slide. Okay, this is the last slide from my part, and here let's look at some mechanics of payment and some nuances for the documents that might be needed at the stage of repayment. As was mentioned earlier, cross-border payment procedures are clearly regulated by the National Bank of Ukraine. And the draft law actually does not change these provisions and does not suggest to make any changes to the currency control procedures, because this is the authority of the National Bank of Ukraine. So we may assume that more or less, even if the draft law is enacted, the currency control provisions for certain period of time until the National Bank of Ukraine decides to change it will remain the same. So basically, let's have a look at some mechanics. If we are talking about disbursement of a loan from a foreign creditor, foreign lender to a Ukrainian farmer, this should go from first of all, in foreign currency, typically US dollars, euro, British pounds, the most common currencies. The loan should be made in foreign currency from lender's bank account outside of Ukraine to the farmer's bank account in Ukraine. And if we are talking about delivery of goods under the general rule, the goods under the supply contract should be delivered to the farmer to the territory of Ukraine with relevant customs declarations confirming import of goods into Ukraine. If we are talking at the same time, if we are talking about payments by the farmer under the financial crop receipts that should be made to the non-resident creditor, the legislation clearly, NBU regulations clearly define what should be the documents to be presented to the servicing bank in order to buy foreign currency and transfer currency outside of Ukraine to pay under the crop receipt. So basically, these are, first of all, copy of financial crop receipt. Secondly, extract from crop receipt register. Thirdly, the contract based on which the crop receipt was issued. So this would be either loan agreement or good supply contract. And finally, this is a tricky one. That's why I mentioned in the first place the mechanics for payment or delivery. Also, the Ukrainian bank, before allowing transaction, would like to see documentary evidence that the farmer received goods or funds from non-resident. So in case of a loan, this should be evidence that funds were credited to the farmer's bank account. And in case of delivery of goods under supply contract, this would be customs declaration confirming arrival of goods to the territory of Ukraine in the name of the farmer. So basically, the legislation is quite clear. I mean, if there is no event of default, payment is made by the farmer voluntarily. The farmer provides these documents. If there is an event of default under the financial crop receipt, this will be the bailiff who would collect and provide relevant documents to the bank in order to make payment. And we assume that the bailiff has already enforced collateral, so the bailiff is keeping money, has already collected money for the non-resident creditor, and here are the procedures in order just to transfer, buy foreign currency and transfer money outside of Ukraine. There are no annual limits at present. There are no annual limits for farmers to make payments under financial crop receipts outside of Ukraine. There are no interest rate caps at present. But it would be fair to mention that the servicing bank would, of course, monitor if the payments under the crop receipts are in line with market conditions. Because if it's too high, the price which is paid is too high in the opinion of servicing bank, then the servicing bank may request additional the farmer or the parties to provide additional documents in order to justify that the price paid is fair. I think I covered my part of the presentation, and I would like to pass the word back to Kirill.
Thank you very much, Taras, for your clear explanations of the new and existing models for non-residents. And we're coming to the end of our webinar. And just to summarize, that the new draft law on crop receipts will definitely make easier and cheaper by turning the existing documents into electronic form and enabling operations online with the use of user cabinets in the crop receipts register. And we are trying to introduce in the new law a standardized form of a crop receipts, which will cover the 99% of all provisions that are currently which currently exist in the current environment, and authorizing installment settlements and opening up more options for settling crop receipts, for example, with the use of partial payments, and that will enable, for example, long-term finance. You will not have to wait until the due date has come, and you can start enforcement on each part of obligation once it's past due. So the second biggest change in the law is that the better protection of creditor rights, which due to the enhanced enforcement mechanism, which will allow seizing all assets in case if future crops are not available or were not found by the bailiff. And we are clarifying some rules for export clearance for commodities shipped within commodity crop receipts enforcement procedure. Of course, we are creating new business opportunities for those clients that work in the livestock breeding and in agricultural servicing cooperatives, and we creating grounds for the second phase of our project, which we hope will be soon confirmed and approved. And the second phase will be dedicated for securitization the agricultural receivables, and will enable and create more opportunities for refinancing, because what we can observe now is that some creditors in Ukraine already reached their country limits, so they would like to off-balance their credit portfolio or to attract refinancing from abroad or inside Ukraine. I think this is it from our side. We're appreciating that you invested some of your time in your new knowledge and took part in our webinar. So we are open for any questions you may have. I would like to say that we will send the slides to all the participants that took part in our webinar today, and the video recording will also be available. So probably we will send the link to the video. Or the second option is that we have a YouTube profile on crop receipts in Ukraine, and we will also happily share these links and slides with you, of course. So this is I believe, the response to Pavlo. Of course, we will send in English. Okay, another request is to send the slides in Ukrainian. We don't have in Russian, but we can send the slides in Ukrainian, definitely. So we will do that. And thank you for your feedback, Pavlo. And the last thing I would like to ask you is to go through the short survey, but unfortunately this is our fault. We forgot to translate this in English. So the first question is this consultation was useful? So please give us your response. We hope that once the law is passed, we'll probably repeat the series of webinars, and the legislation by that moment would be much clearer, so we can make any amendments to the slides we just demonstrated to you. And the second question I would like to give answer to is if you received all answers to your questions that you have. So Florian, a big excuse from our side for all English speakers here that we didn't manage to translate this survey, but do your best attempt, please, to give us your response. Thank you. So again, thanks for coming, thanks for attending, and I hope to see you on our next webinars next time. Thanks very much. Have a great day and stay healthy.
Thank you.
Goodbye and thank you, Taras. Goodbye. Have a good day.